Boys, I'm back here at Waverley Local Court today. That's the courthouse just behind me in the background, and I've appeared on an offence which is very typical to this area of Sydney. It was a minor drug possession offence of cocaine, and the way that our client was caught was very typical of how many of these offenders are getting caught these days. It was a dealer cocaine transaction where basically my client had been out with friends at a venue in Bondi. He'd been drinking for several hours. He was somewhat intoxicated. His judgment was clouded, and he sourced a number from a friend to call a dealer to get a small package of cocaine delivered, and he went outside the venue. Because this is such a common form of transaction and offence in this area, undercover police are just hanging outside venues and watching people and just following them along and watching transactions take place left, right and centre every weekend. That's why there's so many of these types of offences before the court at the moment. And that's exactly what happened here. They watched our client come out of the venue, look at his phone, look around the surroundings, look a bit jittery, followed him around the corner, saw a car pull up, exchange take place. They followed my client. My client actually then disposed of the cocaine on the ground once he realised that police were following him, but they saw this, they caught up with him, and my client confessed to purchasing a small amount of cocaine and took it back to where he'd thrown it on the ground. Probably much to his own detriment. He was overly honest with them, but still very cooperative, and that showed immediate remorse. So he was charged with possess a prohibited drug for cocaine. It was quite a small amount, obviously for personal use. Including the packaging, it was 0.7 of a gram, and he paid $250 for that. Now, the problems for my client, in most situations, not all, but in many situations throughout New South Wales, obviously each case is dealt with on its own merits, but if it was his first offence, I would have been here before the court asking for a no conviction. But unfortunately that ship had passed a long time ago, since he had been charged with two drive with illicit drug charges, basically drug driving offences, two of them late last year, in December 2021. Those matters were before the court early this year, before the same magistrate, and he was given two Section 10 or two conditional release orders, which is no convictions, and he's put on a good behaviour bond for a period of 2 years. Now, some 8-9 months later, he's now been charged with a possess a prohibited drug, obviously not traffic related, but still drug related. So, as the magistrate said, you were warned on the last occasion, any further offending and you would not be given the benefit of a no conviction going forward. And it was like the court viewed it like he was rubbing the court's nose in the previous level of leniency that he was provided. The court had no other option really but to record a conviction today. He was given a small fine of $450. We were able, however, to convince or persuade the magistrate not to take any action on the previous good behaviour bond and the breach of that bond. So part of the 2-year no conviction good behaviour bond that was delivered early this year for the two drug drives was that he was to remain of good behaviour, not reoffend in any sort of way for the next 2 years, and then he's obviously breached that good behaviour bond. So due to the fact it was traffic related, it was a different drug involved on the last occasion, and due to the fact that any loss of licence would mean he would likely lose his job, the magistrate just fell on our side and agreed not to take any action on the breach of the previous offences. If he had have taken action on that, he would have convicted our client for the past offences, put him off the road for a period of time, and that would have had detrimental outcomes in relation to our client keeping his job. So in one respect, he was convicted today of the drug possession, the fresh offence. That was almost to be expected, but in the other sense, it was dealt with quite lightly, in the sense that no action was taken on the breach, so he was able to keep his licence today. Our client was very understanding. We explained to him that he would need to expect a conviction for the fresh offence, but we were a little bit unsure as to how the magistrate would lean in relation to taking action on the breach. So it ended up good for our client today. He was given a very, very stern warning by the magistrate, simply saying, listen, any further offending, you do face the risk of potentially going into custody, and explain to him that it's just an attitudinal issue from our client's perspective to continue to go out and reoffend in the same way. He needs to stay away from drugs, stay away from the bad influences and the bad substances in our community. He's got the good support of his family, and hopefully this will be the last time he needs to contact us. So thanks for tuning in here at Waverley Court, Eastern Suburbs. I want to thank you for tuning into Boorman Lawyers today. You can catch us at any of the usual social media platforms. Please subscribe to our YouTube channel. And if you've got any questions or queries, please don't hesitate to contact us on 1300 941 900. Hey guys, thanks for tuning into this video today. I really hope it was informative and helpful for you. There's another couple of videos below that you might want to check out that may be very useful for the process that you might be going through at the moment. Please feel free to like, follow, share, and subscribe to our YouTube channel, because we've always got fresh new content coming through all the time.